No state knows the human toll of the opioid crisis better than West Virginia, which has seen more overdose deaths per capita in recent years than anywhere else in the country. And in the state's capital, Charleston, this week, 3 of the nation's largest drug distributors are on trial for the first time in federal court, facing claims they helped fuel the opioid disaster. Lawyers for the plaintiffs, Cabell County and the town of Huntington, pointing to the massive volume of drugs sold in the state. Reporter Brendan Pearson is covering the trial for Reuters.
They really focused on kind of the sheer size of the opioid epidemic as it's impacted this region, talking about hundreds of millions of pills flooding the area and the consequences of widespread addiction, opioid abuse. And their argument is that the 3 distributors, AmerisourceBergen, McKesson, and Cardinal Health, ignored what should have been warning signs that these pills were being diverted into illegal channels.
One expert estimated the related health costs to the region at $2.6 billion. But in their opening statements before District Judge David Faber, the 3 companies on trial said they were merely the middlemen in a tragedy set in motion by drug makers, doctors, and even U.S. regulators.
The defense's position in this really is that there was a big push toward treating pain more aggressively, kind of an idea that pain had been undertreated in the past. So there was a big increase in prescription by doctors during this time, and the distributors would say, we were just distributing drugs that were prescribed by doctors. We weren't marketing them. They're making the argument that they did report suspicious orders and that authorities didn't do anything about it. And I think that's going to be a big factual dispute in the trial.
The West Virginia plaintiffs opted out of a proposed $26 billion national settlement offered by the 3 distributors and Johnson & Johnson.
They clearly think that they are able to get a better sum, a better amount, a better outcome from trying their case in court.
Professor Elizabeth Birch of the University of Georgia's School of Law has been tracking opioid litigation around the country. She says the West Virginia trial serves as a test case for how well public nuisance law may apply to opioid litigation nationwide.
Well, I think that's the multiple billion dollar question right now, is that this is a test case. This is one of the cases that was remanded from Judge Polster, who is presiding over multi-district litigation up in Ohio. He sent this case back to West Virginia to have it tried in front of a West Virginia judge. And so I think, this will have a lot of ramifications because it will really sort of set a benchmark to a certain degree as to whether the defendants here, the distributors, are culpable. And Cabell County and Huntington counties are both alleging that the distributors contributed to this public nuisance, and so they should be required to abate it, in other words, to fix it. Although typically we think about public nuisance in a very different way, right? So like fireworks or hog pens. This is a different application. It's a novel application of what we think of as public nuisance law. And I think that's where that kind of testing comes in, is how far does public nuisance stretch? Does it stretch far enough to cover what we're seeing in the opioid epidemic? Or is that maybe a bridge too far?
The answer could influence the outcome of some 3,300 opioid lawsuits around the country. That's today's Case File. I'm Tom Rowe in Washington.